D.C. Attorney General initiates legal action to prevent federal overreach, referencing the Home Rule Act. Washington, D.C., August 2025. In a significant legal maneuver against what city officials characterize as extraordinary federal overreach, D.C. Attorney General Brian Schwalb has initiated a lawsuit aimed at obtaining a temporary restraining order, TRO, against the Trump administration. This lawsuit contests the attempts to federalize authority over the Metropolitan Police Department, MPD, which Schwalb contends infringes upon the 1973 Home Rule Act. The Federal Authority Initiative. On August 11, 2025, President Trump invoked Section 740 of the Home Rule Act, proclaiming a public safety emergency and asserting federal control over the MPD for federal purposes. This invocation represented the first actual application of this authority in the history of D.C. The order included the appointment of DEA Administrator Terry Cole as Emergency Police Commissioner, effectively removing local leadership, including MPD Chief Pamela Smith, from command. Shortly thereafter, on August 14, U.S. Attorney General Pam Bondi issued a directive to Mayor Bowser formalizing this alteration, revoking sanctuary protections, altering enforcement priorities, and placing MPD leadership under the authority of a federally appointed individual. Schwalb's legal counteraction. Attorney General Schwalb promptly reacted, issuing a memo to Chief Smith stating that Bondi's order is unlawful and informing her that she is not legally obligated to comply with it. He subsequently filed a legal complaint in federal court, seeking a declaration that the federal directives contravene the Home Rule Act, the Administrative Procedure Act, and the U.S. Constitution. A preliminary and permanent injunction to prevent Bondi's takeover. A TRO to inhibit DEA Administrator Cole from taking any command role over the MPD. In Schwalb's view, this represents the most serious threat to home rule that the district has ever encountered, undermining self-governance and endangering public safety. Federal judges' preliminary decisions. A federal judge has supported D.C. officials sufficiently to maintain local governance, determining that the law does not allow for the complete replacement of the police chief, thereby upholding Chief Smith's position. Nevertheless, the judge suggested that some federal assistance might be allowed, indicating ongoing disputes regarding enforcement authority. As a result, the White House adjusted its strategy, permitting Smith to maintain daily oversight, although the Justice Department continues to be proactive in enforcing federal immigration policies. Understanding the Home Rule Act. The Home Rule Act of 1973 established self-governance for the District of Columbia while granting Congress, and by extension, the President, limited powers under certain conditions. Section 740 allows the President to request MPD services for federal purposes during emergencies, but such requests must be routed through the mayor and are strictly time-limited, 30 days at most unless extended by Congress. The President does not have the power to take control of operational leadership or to override local regulations. Significance of this lawsuit. Protection of self-governance. D.C. officials view this as a direct challenge to long-standing legal boundaries intended to safeguard local autonomy. Implications for public safety. Imposing unfamiliar leadership and directives on MPD could create confusion, delay responses, and undermine trust in law enforcement. Constitutional considerations. Opponents contend that this action tests the boundaries of federal authority, raising concerns about the separation of powers and state sovereignty. National implications. There is concern that permitting such intervention could set a precedent for similar federal actions in other cities, particularly those governed by political adversaries. Future developments. The court must decide whether to issue a formal temporary restraining order, TRO, which would immediately halt federal directives, and whether Schwalb's lawsuit holds merit regarding its broader claims.